Special Education Overview. In this presentation, we will discuss the provisions of the special education laws and describe their implications for the classroom. Special education is relatively new, and much of what has happened in special education has paralleled the civil rights movements. In 1954, there was a lawsuit known as Brown versus the Board of Education of Topeka, Kansas. During this time, students were placed into schools on the basis of race. However, the courts ruled that separate is inherently unequal. In special education, we refer back to this ruling quite frequently. Before 1975, students with disabilities were often excluded from schools. Some students with mild to moderate disabilities were even institutionalized. However, several parent groups band together to advocate for their children. PARC, the Pennsylvania Association for Retarded Children, sued the school district in 1972 and won the right to have guaranteed special education for children with mental retardation. In 1972, another lawsuit, Mills versus the Board of Education, extended the right to special education to children of all disability categories. Yet the first federal law for special education was not passed until 1975. This law, PL 94-142, the Education of the Handicapped Act, was the first special education law which guaranteed a free and appropriate public education to students aged 3 to 21 who had disabilities. This law serves as the foundation for special education. In 1986, the special education law was expanded to include students from the ages of birth to age 3. This section of the expanded law is known as Part C. Then, in 1990, the law was reauthorized and renamed IDEA, the Individuals with Disabilities Education Act. This law was again reauthorized in 1997 and yet again in 2004. There are several major provisions of IDEA. These include the concepts of zero reject, free and appropriate public education, least restrictive environment, non-discriminatory evaluation, parent and family rights to confidentiality, and procedural safeguards. The rest of the presentation will discuss these provisions. Zero reject simply means that no child with a disability may be denied access to a free and appropriate public education. This principle applies regardless of the nature or severity of the disability. Quite simply, no child with disabilities may be excluded from a public education. This applies to any schools that receive federal funds. Free and appropriate public education is exactly that, an education in public schools that is free to children with disabilities. FAPE, or Free and Appropriate Public Education, is defined as an educational program that is individualized to a specific child, designed to meet that child's unique needs, provides access to the general curriculum, meets the grade level standards established by the state, and from which the child receives educational benefit. Least restrictive environment is the concept we use to provide services to children with disabilities. LRE means that a student who has a disability should have the opportunity to be educated with non-disabled peers to the greatest extent appropriate. They should have access to the general education curriculum or any other program that non-disabled peers would have access to. The children with disabilities should be provided with supplementary aids and services necessary to achieve their educational goals if they're placed in a setting with non-disabled peers. When considering where students should receive their special education services, we apply the concept of least restrictive environment through a continuum of placements. In the continuum of placements, general education classrooms are the least restrictive placements. Services in the general education classes are also known by the word inclusion. If students can spend much of their day in general education but need to be removed for specific skill-based instruction, they may receive special education services in a resource room. Some children, however, require more intensive intervention. These students receive services in a separate class where most, if not all of the students in the classroom are eligible for special education services. From here, the continuum continues to get more restrictive with separate school placements, residential facilities, home, and hospital placements. Services in these settings are rare and should only be used if the other options are not in the child's best interest. Under IDEA, children have the right to a non-discriminatory evaluation. Many norm-referenced standardized assessment instruments discriminate against people from minority, cultural, and lower socioeconomic groups. There has been a trend for the overrepresentation of minority groups in special education classes and the underrepresentation of the same groups in classes for gifted and talented students. In order to address this issue, IDEA requires schools to reduce discrimination by administering tests in the child's native language, as well as using tests that have been specifically validated for the purposes for which they are being used, conducting assessments using a multidisciplinary team, and using more than one instrument to determine eligibility for special education. Although these requirements do not guarantee non-discrimination in assessment, they should help overcome the bias that often results in inappropriate labeling and placement of children from minority cultural groups in special education. Because teachers are classroom leaders, they must closely evaluate their personal attitudes towards expectations of culturally different students. Effectiveness has to begin with tolerance toward and acceptance of culturally and linguistically different children. Another provision of the special education law is the provision of confidentiality for the parents and families of children with disabilities. This provision is very simple. Information about children with disabilities should not be shared with anyone who is not working directly with that child. Parents have to give permission for special education records to be accessed by anyone not working with their child. Even more importantly, anyone who accesses this information must keep it confidential. Along with confidentiality, there are many procedural safeguards in place to make sure that parents are fully able to participate in their child's educational programming. They must receive prior written notice about any meetings. Parents have the right to informed consent before any formal testing or evaluations occur. They have the right to access their child's educational records. And if parents do not agree with the child's records, or if families do not agree with the outcomes for formal evaluation assessment results, they have the right to request an independent evaluation. Their child has the right to education in the least restrictive environment, as previously mentioned. If parents do not agree with any IEP team decisions, they can dispute the outcomes, go through mediation, and/or request a due process hearing where their arguments are heard in the court of law. All of these procedural safeguards are meant to ensure the parents can fully participate in their child's educational planning. Students who receive special education services may qualify for related services under the provision of the IDEA law. These services are provided if they are deemed necessary by an IEP team. Some of the related services included in the law include transportation, interpretation, psychological services, physical therapy, occupational therapy, and speech therapy, to name a few. So, who is eligible for special education services? The disability categories are listed on this page and will be gone over in greater detail in future presentations. It is important to note that just because a child is found eligible by a medical professional does not mean that this child is eligible for special education services. The disability must impact the child's ability to participate in the general education curriculum. This can only be determined by the IEP team. About 9% of students ages 6 to 21 receive special education services. Some of the largest groups of students are students with specific learning disabilities, who account for nearly 50% of the students with disabilities, and students with speech or language impairments comprise about 17.9% of the students with disabilities. There are several groups of students who are not eligible for special education students. Students who are deemed gifted and talented are not eligible for special education students, even though they can be at high risk for school failure. Students who have ADHD are not necessarily eligible for special education services unless the IEP team determines they meet the eligibility requirements under the category of other health impairment. Students who are at risk for school failure do not qualify for special education services under Part B of IDEA. And remember, Part B is the section of the law that relates to children ages 3 to 21. Throughout this presentation, we've mentioned the IEP team. So, who is a member of the IEP team? Well, the parent is a required member of every IEP team. The parents also have the right to bring representation with them to the meeting. Another required member of the IEP team is someone from the school who can guarantee services. This is typically a school administrator. A special education teacher and a general education teacher must also be at IEP team meetings. Any related service providers working with the child, such as occupational therapists, physical therapists, or speech providers, may also attend as team members. In this presentation, we have discussed some of the major tenets of the special education laws. Please know that this has been a brief overview and is not comprehensive enough for you to fully understand the laws. We have reviewed the basic parents' rights and procedural safeguards. It's important to remember that special education is a service, not a placement. Students must be included in the general education classroom to the maximum extent possible.